Okay, I had some questions about the deed. This is the deed that I created. Very simple little thing. We'll go through it right quick and show you what we did. First thing you need to understand about legal stuff, it's your stuff, you can do what you want. As long as you file, as long as you keep with the format that they're used to seeing, the font size, the borders, and the headings are done properly. I don't care what's in the body of that thing much. As long as you do it, follow their basic forms, you can do whatever you want. I create new legal documents all the time. I've been doing it for years. And they say, well, you can't do this. Sure, I did. I did. Who's going to tell me I can't? Who's to stop me? I do it all the time. And I win too, by the way. And this is just a deed. This says deed. It doesn't say warranty deed. Actually, the proper name of this would be called a deed in fee. If it was actually named, that's what I would call it. I put that in the body, but I didn't want to cause a ruckus. So I didn't put it in the title, but it's in the body, so it's still the same. It says, no all men by these presents, that in consideration of $25 in gold and or silver coin and other good and valuable considerations in hand paid in the grantor's name by the grantees, names, the signature of the grantor is acknowledged by the notary and the witnesses undersigned below. This deed is to the below described land, has been delivered, accepted by the grantee, and we hereby take possession and do occupy the land. The grantor does for himself and his heirs and assigns convey this lawful deed in fee, simple to the grantee, his heirs and assigns forever, without encumbrance, including all hereditaments and appurtenances. That's two words we need to go over. The grantor agrees to defend title to this land in the event that the question of lawful ownership arises at a future time. It's that simple. Now, what is a deed in fee? In common law, a deed in fee was one of the most powerful deeds. It means you had absolute title to the land. You could use it however you chose. Okay? It was not ownership because patent was on the ownership, but it was the highest deed that I could find. It's called deed in fee. Now, I didn't put it in the title, but I did, if you'll notice, in the body of the text. Okay, you put your legal description in, and you can use this format. It's on your in your information. All this stuff will be in there. You got signatures now. I put in here you can use two common law witnesses. You can also notarize it, or you can do either or. It's a choice. The reason I do my documents this way is because some places it's hard to get a notary. I know there's places out in the Midwest you have to drive hundreds of miles to just get to a notary. They don't have them everywhere. And so what I do is I give you the option. Now you can do both if you want to. I like to do both, but you don't have to. You can do either or, and it's just as lawful. If you do the two witnesses, just do away with it. Delete the jurat. Don't worry about it. If you got two witnesses, it makes a contract in law. So you can do either or. And you can do both. It's your option. You can do it. But that's the deed in fee. It's a very simple document. You put your legal description in there. And that's as good as any deed you can go pay hundreds of dollars to a lawyer to get. He'll hold up in court. Now, of course, if you go to an attorney and take it to an attorney, this thing is no good, because he wants your $400 or $500 to build you a new one. Yes, it'll be on your disc.
Jim, is that need to be signed by the grantor and the grantee?
Yes, I do it both ways. Why?
And so the grantor is the straw man, is that?
It doesn't matter on this. This is a contract. This is a simple contract. It's a legal contract. Has nothing to do with debtor or secured party at this point. This is a contract.
Maybe I missed something. Who's it between?
Between the grantor and grantee.
Right.
The grantor is the one that sells the property to the grantee, or conveys it to the grantee. The grantor is the owner.
No, I understand.
He conveys it to the grantee.
But are we doing it? Is everybody in this room going to do that? Indeed,
it's up to you. If you want to do it, you can do it from your straw man to your real man. Who's going to argue with it? I want them to argue with me on that.
I did that. They told me I was throwing my money away. I said, so be it.
That's right. They're not going to argue that the straw man doesn't exist. That would shut their whole system down if they did that. Would you mind putting it in an order, Judge? I guarantee you can't get it in writing.
strongly argue with you, Tyler.
That's right. So if you have your deed in all capital letter name, you can use that simple deed to convey it to you. Who's going to argue? Yeah. So just use it accordingly, and if you need it, if you don't, if you got a better one, that's fine. It doesn't really matter. The intent is what matters. If you can show the intent in law, that's what matters in law. The form is not as important as the intent. And it's real important the intent is clear, and it's very clear. I don't think there's any room for misunderstanding on that little simple document what they meant to do. And that's all that's required. Okay? I better put my microphone back on. Okay, now I'm going to go through a few documents right quick. If you have any questions, I'll certainly answer them. You'll see how simple this process is. We have a total of 5 documents to do this whole process. All the rest of this stuff was to prepare you to understand it. The process is so simple that a third grader could do it. I mean, it's really that simple. It's so, all of my forms are just fill in the blank stuff. The law is already there. You don't have to worry about the law. It's there. I can promise you it's there. I did the research myself and put it in there. Okay, the next document we have, we did complete the acknowledgement and acceptance of deed form. And what do you do with the acknowledgement of acceptance of deed form? What did I tell you?
Go down and file it at your...
Go attempt to record it at your clerk's office. Why?
With 2 witnesses
With 2 witnesses. Why?
to build a case.
So you can start a case because they're not going to, if they do file yours, they're not going to file the next one probably. Well, they're going to get called and told not to.
Could I go with a notary as a witness?
Yeah, sure.
And just have one then?
Yeah, you could do that probably. A notary statement would be considered because they're an officer of the court. Well, actually, officer of the public, but they can be. Their statement is considered fact in court.
So is that deed optional, that deed, or is that?
Yeah, the deed is optional. The deed is if you need it. You may not need it. The gentleman that brought me the deed yesterday, it's in his upper lowercase name already.
Okay, so, but if we were to transfer that to somebody else, we don't have to do it in regards to our specific process because we've already accepted.
The deed is there if you need it. You may not. You might not. But it's there if you want to use it. And if you don't want that deed, you can make your own. I mean, you can actually, most of the state websites have a deed format in their statutes. You can go around the website and get it. I did that. I sold a $1.2 million piece of property off of a doggone deed off of a website from the state of Florida. Went and downloaded it myself and filled it out. It was that simple. Didn't have any problems whatsoever. Yes?
Do we have to file those in person, or can we send somebody to file them? The reason I ask is because I have a property in a different state. I want to know how much of this...
It doesn't matter. You can have somebody do it for you, certainly, but you need to have witnesses that if they don't do it, you need to do the affidavits. They need to have witnesses. You need 2 witnesses to go with you. Now, if you've got a notary, that's sufficient. But other than that, you need 2 witnesses and affidavits. The more affidavits, the better. If you can get more than that, that's fine. But tell everybody, and I want to tell you this, please, don't go down to the courthouse and make a ruckus. Yeah. Go down there, be nice, be polite, smile. Smile like the cat that caught the canary, because you did. Okay, so just keep that in the back of your mind. Hey, it don't matter what they do. And I'll show you a reason why in a little bit. Okay, the next document that we do, and these do go in order, by the way. And they're all listed on your little check sheet if you'll follow along with me on your check sheet. Checklist that you got. Is the grantee assignee / assignee's notice of update of land patent. Okay. Now you notice at the top it says recording requested by. That's required in a lot of courthouses. They want to know who's requesting this. Okay, so you need to put the name of the owner in there. And after the recording, please return to name a grantor and address, you need to put the address in there where to return it to. And because some places, it's not that way everywhere, but in some places you have to leave it with them and they'll get it back to you in about 3 days. That's the way that's their process in some courthouses, and that's the reason I put that in there. You may need it or may not. These forms are in Word format, in Save As format. You can modify these forms if you don't need that section, but please do not change the wording and the legal stuff in these documents. Please don't do that. I left them in there where they're flexible, but I'm training you how to do this properly, and the legal language is in there. You don't need to mess with it. Unless you're a very educated attorney, don't mess with the legal language because it's important. It's there for a reason. It's very specific. Okay, the next thing we see is the BLM land patent number right here. And where do you think you might get that? It'll be on. Have you got the little example of the land patent with you that we handed out? Look at that and tell. What is the number on that? 73. That's what you would put right there if that's what's on yours. It'll have a number on it. Okay, that's what you use to put right here, is where it says BLM. What does the BLM stand for? Good. Y'all are catching on. Good. Bureau of Land Management.
Homestead certification number.
No, that's not a homestead number. It's a land patent number.
Okay.
It's what goes there.
That's right here? Okay.
Okay. All right. It says, let all men know by these presents that the full legal name of the grantee. And who is the grantee? It's whoever owns the land and is conveying it.
Timmy, do you have
Or
this case that was
claiming it.
supposed to be already? So, in other words, you're...
No, I don't have it in the proper case. I didn't do that.
Okay.
You need to put, if you're dealing in sovereignty, your name is an upper lower case, and always, 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 remember this. Abbreviations are for corporations. Abbreviations are for corporations. Do not use middle initials. Put full legal name and spell it out. Because if you put an abbreviation, that is a straw man. Yes?
And will the BLM patent number always be in the upper right-hand corner?
I don't know that, but most likely.
It is.
I don't know that, but most of them that I've seen were, but I wouldn't swear every one of them are. But it will have a number on it.
We have one here that's in the left and one that's in the right.
Yeah. You got two on the same document?
I got 2 separate land patents.
Oh, okay.
For my land.
Okay.
Traverse 2 different land
Yeah,
patents.
but we'll have a number on that. That is the number of that patent.
That's number in the top.
Right.
That was red, but
That may be the page number 73 or something.
this one says homestead certificate number.
That's what you want. Well, no. Let's see. Maybe.
Homestead certificate number.
Application number?
Well, if you need to put it in there that way to identify this land patent, just put in there exactly what that says.
Put both of them.
Yeah, you can put them both in there. Just if it says homestead certificate number, put it in there as homestead certificate number so-and-so and the application number. Do that.
You're assuming this number is a page number.
Right. I would think that's a book page number.
The lady over here has one with a separate, different number from 73, and it's on the left-hand side.
I don't know, but I would suspect that being 73 is a page number in a book.
I put them on. I put them on.
Yeah, well, whatever you need to do, use a little common sense here, folks. You're adults. Use common sense. Whatever you need to do to identify that land patent, put those numbers right here. You can modify this to represent what you have, because there's no standard across the board for all this stuff. Every president came in, changed it a little bit. Every secretary of state that does stuff changes it a little bit, and you got all kind of variations of stuff out there.
Just like on mine, it says warrant number.
And that's fine. You just put BLN patent number, put warrant number so-and-so. It identifies that document. Yes, sir.
Certificate number the same? That number that...
Just put certificate number so-and-so right there.
Okay.
Just write it in there. Just let them know that that identifies your patent. And I think I killed my battery. Anyway, so just identify the patent right there. That's what you want. Whatever you need to put in there. All right. Let all men know by these presents that you put the name of the grantees, The below signed grantee assignees do hereby severally certify and declare that we hold in fee simple the below described land. I/we bring forward and update the above numbered land patent into our lawful names. This is a formal notice that the grant has been acknowledged, delivered, accepted, and I or we and our heirs and assigns have taken lawful possession or possession lawfully by right of possession of land patent and do occupy the land. What is right of possession? It's a maxim of law. Right of possession is maxim of law that if you have that, you hold the title of that land, you have right to possession. Very powerful international maxim of law. The character and legal/lawful description of patented land is, and then you put all the information, the legal description there, just like it says, meets and bounds. Not parcel and lot number, lot and block number, but meets and bounds. That's the long one. It's about that long. Make sure you get it in there right.
Quick question.
Yes.
I found my warranty deed. I thought I was going to find that information in my
Yeah.
warranty deed, and it doesn't have meets and bounds.
Some don't. Go to your survey. Your survey will have it. Yeah, wherever it was surveyed last, you can find it. And if you know who surveyed it, they'll fax you a copy of it.
I found it from the city at the Platte, so our neighborhood.
Yeah.
And I handed across the top of that.
Yeah, if you tax assessor's office or tax collector's office, if you'll go see them, they'll tell you where to get your legal description. If they give you the runaround like some of the courthouses are doing now, just go to the surveyor. The surveyor has all that. That's how they describe the land, and it has to be done that way. Okay, for a legal survey. All right, now I'm going to read this. This is notice of my preemptive right to possess my/our land pursuant to the Declaration of Independence, 1776, Law of Nations, Treaty of Peace with Great Britain, 8 Statute 80, Treaty of Paris, 1793, Act of Congress, 3 Statute 566, April 24th, 1824, and the Homestead Act of 12 Statute 392, 1862, and 43 U.S.C. Sections 57, 59, and 83. We got some law in here to back this stuff up, folks. And go research it. You'll find it's there. The grantee assignee is mandated pursuant to Article 6, Sections 1, 2, and 3, Article 4, Section 1, Clause blah, 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 and of the 4th, 7th, 9th, and 10th Amendments, United States Constitution, 1789 through 91, and numerous legislative positive laws to update the land patent by acknowledgement, taking delivery, accepting, taking possession, and occupying, and bringing forward the land patent into the grantee assignee's name. This is my or our formal declaration that this process is lawfully executed and completed, being effective non-pro-tunc, means back to the date that you first bought the property. Now that's going to kind of throw the bank in a kink, isn't it? This is the only lawful method that perfect title can be held in our names, per Wilcox versus Jackson at 13 Peter U.S. 498, page 101, edition 264. All questions of fact decided by the General Land Office are binding everywhere, and injunctions and mandamus proceedings will not lie against it. What does that mean?
Tim, I have a question on the date of the deed there. Is that the latest one we just did where we changed it to us accepting the deed, or the original from...
I would go back to the original date.
When we did
Yeah, you can do that, yeah.
Okay.
Yeah, you can go back to the original deed because that's when you showed that you had interest in the property. Because all you got to do is show interest, legal interest. The law is very clear about that. If you can show you had interest, then you can take lawful possession.
Question?
Even a deed or other document can do that.
What if you had something in the will to you, it would go in?
Go back to the date of the will. You can go back to the date of the will, absolutely. Okay. Okay, now where it's talking about all questions of fact decided by the General Office are binding everywhere, and injunctions and mandamus proceedings will not lie against it. What does that mean? In law, that means you can't challenge it. If the BLM has issued a patent on that property, it is settled. You can't even challenge it. Where does that leave them? Nowhere. They don't have anywhere to go. What does that do to them? It takes the standing away to even challenge your claim. And this is all law. Go look at it. This is not patriot mythology. This is law. I don't do the patriot mythology junk. Okay. See Litchfield versus the Register. That is one of the cases, and that's the case site. This document is instructed to be attached to all deeds and conveyances in the names of the above parties and to never be separated from them. That's telling the clerk they can't separate this from your deed anymore. That means if that deed goes anywhere, this goes with it. The required recording of this document in a manner known as non-pro-tunc is mandated and endorsed by the United States positive supreme law and cited by case history in this document. This is a very powerful document, guys. This is one of the things that we put into that case in Utah last week, or last Tuesday, and the judge went, boop, I recuse myself from this case. The notice in effect of a land patent or grant of public land is a public law standing on the books of the state, and every state has it. They have to. They acknowledge land patents. Every single state has it. And you put the state and county name in there, and is noticed to every subsequent purchaser under any conflicting sale made afterward of the date of the original land patent. And this is also documented by Wyman versus Gastrell. A patent alone passes perfect title to grantee, that's Wilcox versus Jackson again, when the United States has parted with a title by patent, legally issued and upon surveys made by itself and approved by the proper department, which would be the BLM. The title so granted cannot be impaired by any subsequent survey made by the government for its own purposes. That is in Cage versus Danks. That was actually a Louisiana case, Daniel. In the case of ejectment, where the question has been who has the legal, what is ejectment? That's when you're forced off your land. Well, so in a case of ejectment, where the question has been who has the legal title, the title patent of the government is unassailable. What does that mean? You can't challenge it. You can't even challenge it. You have no standing to challenge it. Sanford versus Sanford says that. The transfer of legal title patent to the public domain gives the transferee the right to possess and enjoy the land transferred. That's Gibbons and just versus Cotu. A patent for land is the highest evidence of title and is conclusive as evidence against the government. Against who? Even the government can't take it. And all claiming under junior parties or titles, and that's U.S. versus Stone. Estoppel is hereby noticed and has been maintained as against a municipal corporation, and that's Beadle versus Smizer. They told the county you can't even challenge a patent. In Beadle versus Smizer, you don't have any standing to even challenge it. They produced the patent, they won. Until it issues, the fee is in the government, okay, which is by patent passes to the grantee, and he is entitled to enforcement, possession, and ejectment. Okay, the fee is in the government. What that means is that who pays the fee owns the land. The government took the land by different methods. Conquest, by treaty, by purchase. They own the land by right of possession. They transferred that right of possession when you paid the recording fees for the patent. That's what that means. When you paid the fees, it says that, and some of the patents actually say that when you've paid the fees, that one, I don't know if that one does not, but it says the grantee has paid the fees and the grantor lawfully transfers the property to that grantee. All rights, all entitlements, forever. Okay. This is a very, very powerful document, guys. Don't take this for granted. This is true. This stuff is absolute law. Okay, state statutes that give lesser authoritative ownership of title than a patent cannot even be brought in federal court. That was Langdon versus Sherwood. Now what does that say? Say that again. State statutes that give lesser authoritative ownership of a title than a patent cannot even be brought in federal court. Who is the bank operating under? What are they operating under? State statutes. You catching on? See where we're at here? They can't even touch this in a federal court. If you have an issue with a bank and they're trying to claim an adverse possession and you take your patent into that federal court, they are bound by law to uphold your patent. And I can show you case. In fact, I got the thing going around now with all the cases on it. You need to read them. You need to look at at least the summaries of these cases, because it's very clear. And it says, in some of the cases, it says that for a county or a state to come against a land patent in court would be an embarrassment to the process and is not allowed. It's very powerful. The power of Congress to dispose of land cannot be interfered with or its exercise embarrassed. There it is right there. Exercise embarrassed by any state legislation, nor can such legislation deprive the grantees of the United States of the possession and enjoyment of the property granted by reason of any delay in the transfer of the title after the initiation of proceedings for its acquisition. That's Gibson versus Cotu. Now what does it say? They can't interfere with your enjoyment of the property even after the initiation of the proceedings to bring this forward.
So as soon as we file
When you start,
That's what I'm telling y'all. Once you do this, there is nothing they can do. It is checkmate.
Talking about just initiating the patent process?
Yeah, you're already in control when you do that. That's what I'm telling. And this is right out of that was Gibson versus Cotu. You go read the case. That's a Supreme Court decision, by the way, U.S. Oh, that might be, I don't know. It could be district. It's a U.S. court anyway. It's at least federal district level.
What is the point of initiation, Tim?
It's when you fill these documents out and have them recorded.
The moment they're recorded.
The moment they're recorded, that's initiation. Boop, you're done. And they can't even argue it. This is what I'm trying to tell you, the power of this process. When I got to reading and studying the law on this, I said, man, I didn't know we had a tool this powerful. This is so powerful that they can't even challenge it. The only challenge that they can bring to a land patent is if you did it fraudulently. If you don't have lawful title and you can't prove that you really have lawful title, certainly they can challenge that, but they can't challenge the patent. And if you have lawful title, you have a deed in your name, and there's no challenge to that deed. And who can challenge it?
Anybody that's been paying taxes for 10 years.
10 years. And they have to have a deed.
Yeah.
and
Something else.
And possession.
Oh, yeah.
Well, that's 3 strikes, you're out there, buddy. Mr. Banker.
Your octopus up there wants to protect itself.
I'm sorry?
Your octopus up there
Yeah.
is trying to protect itself.
Exactly.
Will they shut down the Bureau of Land Management? What will they do with...
They can't deny us the access to the records. That would be a big federal lawsuit if they did. Yeah, so need to do what I'm telling you. Guys don't know what's coming. I'm telling you without telling you what's coming. Okay? And when I tell you you need to document all this stuff with affidavits and witnesses, I'm telling you what's coming. We're going to need that in the future. And it's going to be much bigger than just going to the local courthouse and filing a case. It's going to be much bigger than just going to U.S. District Court and then filing a case. We are building a case. And I'm telling you without saying too much. Okay? We're building a case. And this case is going to win, but it's got to be done properly. You have to build a case, you got to build the proper legal footing and groundwork. And if you do it there, you will win the case. Documentation. I was taught by some of the best. And they absolutely taught me documentation wins. The best documentation wins every time. And that's what we're doing, is we're documenting the case. So be aware that you need to do this stuff like I'm telling you, because there's a lot more coming that you don't know about yet. Yes?
Tim, are you telling us then that if we come up against people who are up against this kind of stuff, that it's up to them to take care of it, and if we can't help them, they can contact somebody higher up in the Republic that can?
We have 18 people so far on our law team.
Because you're telling us basically that we aren't the ones to get involved in this.
You're not gonna be involved in anything really. The only thing that we want you to do is go offer the clerk the opportunity to record your updated deed. You know, like we're talking about. They're not gonna do it. Like
This is all going to be on print though, so if they
all of this is gonna be on your disc. Everything here.
give it to them?
Right. Yeah, absolutely. Well, the only thing you go to the clerk is the first form that I showed you a while ago, the one that shows that you've accepted your deed.
Would you ask the clerk to see their supervisor and tell the supervisor what happened if they don't?
No, you don't have to do anything. Don't get into a conflict.
Okay.
In reality, we want them to refuse.
Okay.
We just want it documented that they refused, folks. This is a set-up maneuver.
President, this is, would you file this document? No, thank you, sign your document.
Have a nice day. Have a nice day, that's it. Yes, Anisha?
But Tim, some of these properties that we're doing, let's say we're going to do our land patent, we get that all done. But some of us have these mortgages on our, current mortgages on our properties. What's going to happen to those mortgages?
They're going to foreclose.
They're going to foreclose
Sure.
on them?
If you don't pay them, they are. If you don't satisfy the mortgage, they're going to foreclose. So, they're going to send you a foreclosure notice. You're going to say, have a nice day. The sheriff is not going to come move you off your property with a land patent. Because if he does, you're going to take him to federal court. Did you know what you can do once they try to make a movement, an ejectment against you on a patented piece of property? You go down to the title company and you tell them I'm filing a claim on this. And they've got to pay you in full the value of the property. Then you take the bank to court and they have to pay you 3 times the amount. And they have to give you back your property.
I like that.
That's all right, isn't it? It's cool.
Tim, you take that to the title company? You say you take that to the title company?
You just bring them into an action well, you can actually go to them. They'll help you file a claim. But you have to be careful about that because if they help you file the claim, then you give up rights. We don't want to give up any rights. And that's Tom is working on that right now. And pretty soon we will actually be able to go claim the title on the land because of a defective title. Isn't that cool?
Yeah, that's pretty.
So you're going to eventually, and it may take a while because this is going to be a process, but you're eventually going to get the title to your land and you're going to get paid too. Isn't that wonderful?
What's the downside? What's the downside?
The downside is that you won't have any debts and you'll live happily ever after.
Merry Christmas.
Merry Christmas.
If you ever decide to sell the property though, you gotta sell it outright or finance it yourself.
Right. You cannot get a little more. When you do this, you will not find a bank that will touch this property.
Because they can't foreclose.
They can't foreclose on it. Oh yeah. Believe me, folks, you're not going to want to sell your land in the future. I got another plan for that the Republic is going to show you that. Oh my goodness, you can. How would you like to be able to sell your land for full value without ever giving up the title?
And get some revenue back.
And let's still keep it and live on it. We can do that too. And still keep it and live on it. Convey your property, still keep it and live on it, and still own it, and get paid full price for it. And that's wonderful. We can do that in the Republic.
Isn't that having your cake and eating it too?
Yes, it is. Absolutely. But we actually have a plan that will do that. Yes, ma'am.
How would this, once you get the land patent, how does that affect your credit rating as to your assets?
It doesn't affect your credit rating if you pay your debts, but if you decide not to pay your mortgage, which your mortgage has already been paid anyway, once you understand that, but the people that are into foreclosures already, they don't have any credit anyway.
That's true.
Now, I've got good credit. I've got excellent
It's been
credit.
a joke for years.
But yeah, it's all. Believe me, when our banking system comes in, credit scores we don't care about credit scores. We really, that's not what our focus is about. Our focus is about reestablishing the wealth to the people. That's what our banking system is going to do, and I can tell you're going to love it.
This will be the best thing that ever happened to farmers with farmland.
Absolutely.
What we have to do is bring our
Yes, sir. Yes, sir. Daniel?
The first one that you go record with the deed, in my situation, I have a will, so I don't have a deed. How would that?
You have to have a deed made.
So I need,
You got the copy of that deed that I gave you. You can do.
I need to go ahead through.
Right. So you show ownership. So you can show. You've got plenty. You got your father's will, last will and testament that says what you're supposed to receive. So make you a deed.
No, you did.
I mean, that's actually, I've got a case on that. It actually says that.
Okay.
That a will is considered ownership, or actually that the ownership of the property has been passed to the next generation. That's what you call a hereditament. That right now is a good time to look at that.
Well, I was holding off on the quitclaim deed because I thought the patent would supersede that, but now I understand I need a deed.
Well, you got to show title. You want to read this for me, hereditaments? If you will, just read the definition of it for me. This is what hereditaments means.
What edition is that?
Fourth, I think.
Hereditaments, things capable of being inherited, be it corporeal, real, personal, or mixed, and including not only lands and everything thereon, but also heirlooms and certain furniture which by custom may descend to the heir together with the land.
Okay.
Ooh.
Okay. What you have to do is you have to include a hereditaments and appurtenances in your deed because you inherited your land, and that's legal. And now appurtenances is stuff on the land. We don't have to read that. It's just stuff on the land.
Like the outbuildings.
Outbuildings, yeah, or anything on it. Trees, water, minerals, everything. Appurtenances is all of it. Yes?
If land is left to two owners and one of them is a member of the Republic and the other is not, what do we do in that case?
We don't care if one of them is a member of the Republic, they can record their documents.
Okay, so if in that case ultimately the member of the Republic would get a land patent and would be the real owner?
Yes.
Thank you.
Yes.
You just gave me
Of course, your brother.
Well, now I will tell you this. Now, if he has proof that he has title to that land, he can challenge you on a fraud claim and break your patent, though. So you can only patent what you own.
What happens if I wish to patent it, but the other person doesn't understand what's going on and does not wish to patent it?
Well, if he doesn't bring the patent forward, you own the land. He can challenge it, though, and bring his forward, too.
What if I'm going to get some land and I explain this to the other person? Will they at some point, I mean, at what point do I actually get hurt?
You can also have a survey done and separate the property, however y'all choose to do, and just patent your portion of it. You can do that as well. Yeah, you just have to have a survey done. Yes?
In the quitclaim deed, you said you need to have a appurtenances?
And hereditaments. Hereditaments. And see me later and I'll give it to you.
Okay.
And hereditaments means you inherited the land, basically. And you inherited all rights to the land. Okay? All right, let's move on here. Okay, okay, and it talks about where you can't, the state legislation can't embarrass the process, and that they can't delay any transfer of title after the initiation process has been established. Okay, the existing system of land transfer is a long and tedious process involving the observance of many formalities and technicalities, a failure to observe any one of which may defeat the title. Even where these have been most carefully complied with and where the title has been traced to its source, the purchaser must be at his peril, there always being, in spite of the utmost care and expenditure, the possibility that this title may turn out bad. That's Yekel-Torrens System 209. Patents are issued and theoretically passed between sovereigns, and that's Leading Fighter versus County. An estate inheritance without condition, that's what a patent is, belonging to the owner and alienable by him, transmissible to his heirs absolutely and simply, is an absolute estate in perpetuity and the largest possible estate a man can have, being in fact allodial in its nature. That's Stanton versus Sullivan. The original meaning of perpetuity is unalienable, indestructible interest. That's unalienable, indestructible interest. That means it cannot be taken. Cannot.
So with the title and the will, there's no ever concern of this ever coming up for probate or any of this nonsense?
No, sir.
It's all
No, sir.
statutory now.
If you update your patent, you're the owner, period. And there's nobody nowhere can challenge that except in fraud. If you didn't do it properly and they can prove fraud, they can break your land patent. That is the only possible way. And the only way they can do that is to prove that you got a bogus deed, that you didn't really do what you said you did, and you don't have a lawful deed. If you got a lawful deed, you can do this and you will absolutely own the property. Notice, the below signed grantees and signees are in fact through perfected title by land patent, the lawful owners of the above described land held in fee simple, including all appurtenances and hereditaments. If this land patent is not challenged by any and all claimants within 90 days, now you can put 60 in there, I put 90, there was a disagreement between two people that had done it before, and one said 60, one said 90, so I put 90. I think 60 is sufficient. With lawfully documented proof to the contrary, this will be forever default judgment and estoppel against all future claims. It really doesn't matter if you leave the 90 in there, because nobody can once it's initiated, they can't even challenge it anyway. Okay. Again, estoppel against all future claims from any source and absolute title to said described land, and the patent is established for all time, as no one else has followed the proper legal and lawful steps to acquire legal and lawful title. Now, who would that be talking about? Maybe the bank? Can they argue with that? No, there's no way in the world they can. The final certificate or receipt acknowledging the payment in full by the homesteader or preemptor is not in legal effect a conveyance of land. And that's talking about a deed. You cannot take ownership by deed.
Is Rick and the Records Bureau going to be the ones that update or send notification to the Bureau of Land Management?
Our Records Bureau will send, well, you don't have to notify BLM of anything.
Well, how will their records be updated?
They don't update their records.
Oh, because
the patent is forever, it's in their record, it can't be removed, and can't be challenged. They don't update their patents. Their patents are issued, it's your job to update the patent. That patent will never change in BLM.
Okay.
It'll never be listed in your name in BLM.
I had that other guy's name.
Yeah. Yeah, well, because the patent was issued to him, and it can't ever be challenged. So whoever they conveyed it lawfully to, down through the ages, has the right to bring it up. Yes, sir.
Can I add something there?
Please.
What's happening with this, and the reason they can't change the patent, is the patent was issued to a man, a sovereign, okay? It got out of their control. That can't be updated. What we are doing with this process, and while we're calling it updating the patent, is we're showing chain of title back to the land patent.
Yes.
We are deriving our perfect title regarding that land from the land patent, that chain. Okay? So we're linking ourselves directly as if the patentee, or at that time, whoever's named on there, had done a conveyance of his perfect title to us.
Well, my question is then, how does that get to the title company the next time? In other words,
You don't do title companies anymore. You're done with title companies.
okay, so then
Okay.
when
It's recorded in the Bureau of Republic Records. On public? Okay, listen, now that's what we're going to get to, how we're going to do that. Okay, Lorian?
Quickly, I did a search on the BLM for my range and section.
Yeah.
And found 14 hits.
Okay. Well, you got to determine exactly which one is yours.
My question, I don't know the criteria to differentiate except that
You have to call the BLM and give them your information, and they'll track it down. They will do it, yep. That's what they do. Okay, let's finish up here. We need to get done. Law on rights, privileges, and immunities. I don't know how to predict, that's French and I don't know how to say it. Anybody new can speak French? What it means is let right be done to the party. That's what it means, but I don't know how to say it. Let right be done to the party. To the parties. I don't know how to, I'm not French, so I have no idea. Oui, oui, Mich. When land title is transferred by the patentee, title and rights of bona fide purchaser will be protected. What did I tell you earlier? It says, rights will be protected. That's United States versus Debble. United States versus Beeman. State versus Hewitt Land Company. And that was the Washington case. As an assignee, whether he be the first, second, or third party to whom the title is conveyed, shall lose none of the original rights, privileges, or immunities of the original grantee of the land patent. No state shall impair a private contract. U.S. Constitution, Article 1, Section 10. Okay? Now, this is the great part of this. If the bank challenges your title in a court of law, guess what? The title company is going to have to pay you the claim. They got to guarantee the title. So you're putting the bank and the title company against each other.
And they took the fee from us.
Oh yeah, absolutely.
You're the beneficiary.
Okay, so they're going to if they challenge you, they got to pay you. So they can't win either way they go here. There's no way to win. And it says in the law that if they made a mistake, they got to pay you treble damages. Who's going to win this fight, guys?
I'll tell you what, I didn't have all my ducks in a row, so I haven't gone down to the title company yet. So I was real busy, so I had my wife go down there and get some paperwork. But over the phone, I didn't want to press the issue over the phone. So I'm just waiting till I go down there in person. I asked for, the original title policy, the owner's title policy, so fine. And I said, I want everything, I want a complete copy of everything in the file. And she told me, she says, that's our property, we don't have to give that to you.
Okay,
So
that's no problem. You ever heard of?
Secret in those.
Yeah, exactly. Have you? But have you ever heard of a subpoena ducis tecum?
Oh yeah.
Okay. Then this is the strategy you need to remember. Okay, might want to write this one down because this is what's going to make the difference when you go to court. Who are you going to subpoena to court to testify on your behalf? The title company executive. Now what is he going to do in court? Say, no, we didn't check the title? No. He's going to have to defend your title to pay the claim. You're talking about on the hot seat, that joker's on the hot seat because now he's over here, he's going to have to go against the bank or he's either going to have to admit that his company is in default. He don't have but two choices and ain't neither one of them good.
However, that title company usually is writing for a company like, for instance, Safeco or
That's fine.
something like that.
That's fine.
And when they look at that, when that policy is written, an attorney looks at that title. So that attorney also becomes involved.
It becomes a party
That's right.
and liable too.
For people, this is just another thing, is that it never hurts for you to go to the courthouse and look at the book of deeds and book of mortgages, because right now we have a problem with identity. I know of a particular lady who owned her house free and she was going into an assisted living. We're going to sell her home. Suddenly she found out she had a $300,000 mortgage on her house she knew nothing about. So know what your chain of title is.
Right, exactly. You're right. And see, the more this opens up, the more parties you're going to get involved, because not only is the lawyer involved and liable because of the fraud, his whole firm is. Remember, respondee superior. Always remember that. Okay. In federal courts, the land patent is held to be the foundation of title law, Finn versus Holmes. In federal courts? I wonder why. Because it was issued by the United States. You can't, there's no way to lose this. There's just no way. You can't. Unless you're in fraud, they can beat you, but other than that, there's no way. A lawful land patent holder is immune from collateral attack. Collins versus Bartlett. And what does that mean? You can't even challenge it. You don't have standing to challenge. And there's a bunch of cases there for that. Grantee assignee season in deed, that means they've accepted and taken possession of the deed. And lawful acknowledgement, delivery, acceptance, possession, and occupation. Now, do we cover everything? Acknowledgement, delivery, acceptance, possession, and occupation. All 5 elements are covered. Only applies to that portion of stated original land grant BLM number so-and-so as is described by legal description in this document and not the whole thereof. That means that I'm only claiming the part that I actually purchased or was conveyed to me. You're not claiming somebody else's land. You're only claiming your land. This includes all hereditaments, appurtenances, property, tenements, and all rights, including preemption rights and other rights as protected by the law. Now, what is the doctrine of preemption? That means that when the federal government passes a law, a state cannot pass a law that supersedes that law. That's the doctrine of preemption. So that what? Now, who issued the land patent? Who says it's lawful title? Federal government. Can a statute or ordinance or anything, regulation, overcome that? No. Doctrine of preemption says no. And that's why I put that in there.
Now I see why you
And y'all thought I was just another pretty face, didn't you?
That's why I say don't change one word.
Yeah, you don't. Every word means something. I mean, I've done a lot of research, legal research on this stuff. I'm telling you, don't change it. If you don't understand it, that one word means something. And if you don't understand that, that's why I explain these words to you, because you need to know. This recording will not be construed as to deny or infringe upon any rights of lawfully documented owners. Lawfully documented owners. That doesn't mean people are just making claims. Lawfully documented owners. To claim the remaining portion thereof. Any challenges to the validity of this declaration and notice are subject to all terms, conditions, and limitations as stated herein. Failure of any lawful party in interest to bring forward a lawful challenge to this declaration and notice of land patent is as stipulated herein will be latches and estoppel. That means that's the end of the road, buddy. You can't, if you don't do it within the 90 days, you are never going to be able to do it. You're done. To any and all parties of interest, failure to make a lawful claim as indicated herein within 90 days of this notice will forever bar any claimant from any claim against my or our allodial estate as described herein. We will be final judgment herein fail not. And of course you've got the signatures of the grantee and assignee and the jurat for the notary. This document is a very, very, very powerful document. Because it not only makes the claim, it verifies the claim. This is what we refer to as a verified notice. It means it's got the law to back it up.
The public notaries.
I'm anticipating that the professional, astute criminals, seeing that this is an impenetrable wall, are going to invent a new way to steal identities or whatever to try to get in their system.
There's going to be an attempt for people to try to take advantage of this process, but remember, and I've said it at least 4 or 5 times already, if there's any fraud involved, your land patent is no good. If there's any fraud involved in ownership of that property, your land patent is not worth squat.
So if the bank did not do their paperwork correctly, for instance, you know, when you have title search or whatever, when you bought your property, but conventional, and it can be shown or made difficult to defend yourself against an accusation, your existing title is fraud.
So you're defending it now. This is what you're doing. Okay, if you've got a deed and you can show that you received a lawful deed and accepted that deed, which is the first process we do, then nobody else can challenge you. Yes, sir.
If you personally bought property at a tax deed sale or a sheriff's sale, can you create a deed that is lawful for the person that was house was stolen from?
If you buy a tax sale property and the former owner of that property protested it and they find out about this process, they can take it from you, yes.
And they should be able to.
And they should be able to because it was taken by fraud. So be very, did you read what I said? Buyer beware in here? I read you the side out of the law that says you better be careful because even the most careful consideration and investigation into the lawful property rights can be overturned by this. So you got to be very cautious. Don't buy anything that's questionable. Yes, sir?
What were the, up above, what were the two signature, what did they say on both those signature lines? There's two separate signature lines, is that right? There's one for print and name.
Grantee and grantor.
That's the grantee and grantor.
Okay.
That's the signature of the grantee and owner.
In our particular instance, who's the grantee going to be?
The grantee is who receives the deed. The grantor is the one who executes the
Right,
deed.
who will that be?
The transfer.
Say my instance, is it going to be the living man granting it to the living man?
No, well, in your day, you don't even need to. Yeah. You could do it that way.
You got grantee on both, is that supposed to be husband and wife?
Oh, I'm sorry.
Or is it supposed to be grantee grantor?
Oh, okay. No, okay. This is no. You don't. The grantor doesn't sign this. This is a grantee. This is acceptance. Yeah, this is in case you got more than one, like a husband and wife.
Okay.
That's why I put that in. I just thought about that. Okay. I was.
Upper lowercase.
Yes, ma'am.
It says full legal name,
Yes.
okay, on my driver's license.
Mm-hmm.
It has
That's your straw man.
my first name, my maiden name, and my married name.
Mm-hmm. What does your birth certificate say?
Okay, is that what would go back?
Yes.
They issued another social security card
Mm-hmm.
under my maiden, my married name.
Probably. They usually do. And you need to use whatever your given name was at birth on your birth certificate. Well, now you can put your married name too, but you know, like most women, you can use your married name, but you need your first name. Your last name is your family name. Okay, it's really belongs to your whole family, not just you. So you use your first name, your middle name, and you can use your married name because it's already, if you have a legally married, if you have been lawfully married or legally married, you can carry your husband's name legally. That's fine.
And Tim, as I understood what you said before, in order for us to approach and put this paperwork into the Bureau of Public Records, we have to get refused to put it into the...
No, you don't care if they file it or not down there. They're going to refuse. The purpose of even going to the county is to build a case. Most of them won't file it. Some of them might. We don't care. It has no effect on it anyway. Because all you're taking down there is just your deed and that one paper. You're not taking the rest of it down there. Just that one deed and one paper.
You don't want us to attempt to file the land patent?
No. All they're going to get is a notice. Okay, we'll get to that in just a bit. Okay, it's lunchtime. We're going to have to take a break for lunch. Need to break here because the rest of that's just the jurat. And we'll come back and we'll get on the rest of our documents. I got to go through these documents. But you can see how easy these documents are to fill out. All you do is where the highlights are red, you put the stuff in there. That's it. What it says. And this is so easy. But I'm trying to make sure you understand the power of this process. The law is there, folks. Go study it. Go read it. It's there.
Tim, do you want any spelling corrections?
Yeah, if there's any spelling corrections, sure.
Here, I need you to call home.
Okay. Listen up. Be back at 1:30. We got a lot to cover.
Want me to give it to you in writing?
Just wait. Give it to me later. Right now, I'm kind of busy.
Mine says third party, that's the same as agreement.